Case number 114895, in the interest of T.S., a minor child.
May it please the court, my name is Jennifer Hill. Myself and Aaron Summergood appear on behalf of the petitioner in this case, the grandfather. I would like to reserve 5 minutes for rebuttal time, Your Honor.
5 minutes is granted.
Thank you. Today we are talking about a case related to a jurisdictional question on appeal. This is under Chapter 38, Article 22. This is the statute. The statute in question is 38-2273 subsection A. That statute specifically governs what matters are available to be appealed as we go through a child in need of care process at the district court level. In this case, I think it's helpful to know kind of how we got to being here is that in April of 2013, the grandfather in this case, my client, filed a child in need of care action. Typically, those are filed by a district attorney or by the state of Kansas, but in this case, we have a private cause of action that's been filed. The grandfather determined that in order to do what was in the best interest of his grandson, he needed to have this process go through the juvenile court system. In September of 2013, the district court did an adjudication and determined at that time that the minor in this case, T.S., he was in fact in child in need of care, and various orders have been entered and changed and modified and entered and re-entered over the course of about a 2-year litigation process. In December of 2013, so 8 months after the child in need of care case was brought, grandfather then filed a motion to determine that the biological father in this case was both unfit and that his parental rights should be terminated in this case. The reason we waited 8 months was because in order to get through this process, there's just certain things that have to be done. You have to work with social workers. There was an attempt at reintegration. There were various CSOs assigned, and all of that occurs over the course of 2 years. Finally, we'll go back 1 second. In September of 2014, so about 9 months after the motion to terminate was filed by grandfather, biological father files a whole bunch of motions, including one to recuse Judge Rumsey, who was the district court judge assigned to the case. That order got denied, the case got reassigned, it kind of worked its way through the system, but finally, in February and March of 2015, we have a 6-day trial to determine whether or not biological father is a fit parent or not. Judge Brooks made a ruling at the conclusion of that trial. The ruling was essentially that father was unfit, that permanent custodianship would be assigned to grandfather and maternal aunt. And despite all this evidence of unfitness, and despite actually pages of judge's ruling establishing all the ways that biological father is unfit, then Judge Brooks makes a one-sentence ruling, which is, but it's in the best interest of the child not to terminate. So Judge Brooks keeps the parental relationship intact, and then we end up in the Court of Appeals. Father appeals the determination that he is unfit. Grandfather cross-appeals Judge Brooks' denial of the termination of rights. So that's how we're in the Supreme Court, because the Court of Appeals decided...
You're up in the Supreme Court because of the question of whether we have jurisdiction to hear the appeal. That's right. The main reason you're up here.
Right. So the Court of Appeals affirms Judge Brooks on everything. He affirms that Judge Brooks' ruling on unfitness, but then says we don't have jurisdiction to hear grandfather's appeal from the termination question. So there's a history of relevant cases that this court and the Court of Appeals have studied this issue, and it gets down to statutory interpretation and all kinds of interesting facts. In 1993, the Kansas Court of Appeals determined that the denial of termination by a district court judge was in fact an appealable order. This is the case called In the Interests of TDW and SW, that's 18 Can-App 2nd 286. Then this court decides a case not related to termination, but to post-termination orders in a case called In the Interest of NAC. And in that case, there's an extensive discussion on the jurisdiction to appeal child in need of care orders. And then in 2015, 1 year after NAC, the Court of Appeals decides in the interest of AS, which is 52 Can App 2nd 173, that the Court of Appeals cannot hear, does not have the jurisdiction to hear an appeal from the issue of denial of termination of parental rights. I think it's important in this case that we study your decision, frankly, in the case of NAC, because there's a lot of policy arguments, a lot of discussion about what is it that we're doing in a child in need of care case. This court goes through in the NAC argument and discusses the timeline of a sync case. A sync case is an unusual and sort of its own sort of matter in this situation. You have a petition to determine a child is in need of care, and immediately after that petition is filed, there's a determination of temporary custody. Then there's an adjudication. Do we think this child really is a child in need of care under the statute, or is it not? Then there's a disposition following that adjudication. This court has specifically stated that the entire goal of the Child in Need of Care Code is to find permanency for the child in question. The goal of these statutes, the goal of this process is to get this child who is potentially in danger of abuse and neglect, to get that child to a permanent placement. And a placement that's obviously in the child's best interests. In this case, we discuss the fact, or in the NAC case, this court discusses the fact that the appellate jurisdiction statute, this KSA 38-2273A, discusses 5 categories of orders that can be appealed. It doesn't say
only one that would apply here potentially is one on termination, right?
correct.
So let's talk a little bit about statutory interpretation. So is the statute ambiguous in your view?
I don't believe it is, Judge.
Okay.
I don't believe it is, because the statute itself uses very broad language.
Before you get there, I want to clarify. You're indicating, or your position is that any order of disposition or disposition is one of the 5 items listed. And you're saying that this can't be construed as a disposition?
I'm not saying that, Judge. What I'm saying is...
Well, you answered my colleague, and you said the only one you're relying on was the last one, which is termination of parental rights. It says what we're talking about, an appeal may be taken by any party or interested party from any order of temporary custody, adjudication, disposition, finding them unfitness, or termination of parental rights. And what I want to know is, are you hanging your hat solely on that last part, termination of parental rights? Or are you alleging that the denial of a termination is a disposition?
Well, if we went there, Judge, I think we could.
Well, I'm
Based on your
I'm not
dissent.
going anywhere. We're going where you take this
Right.
case and where you make the claims, and I'm trying to nail down what your claim is.
It is the petitioner's position that it is under termination of parental rights. However, based on your dissent in NAC, there is argument that the term disposition is much broader than any of these other orders that are outlined in that section of the statute. And if you want to take that argument forward, it is very arguable that disposition could include the denial of termination of parental rights. That said, the way the statute itself reads with the language of any, it would certainly seem to include this language of an appeal may be taken from any party or interested party from any order of, and then these 5, as this court describes it, categories.
Are you
What
also
would be-
relying on the any that precedes party?
Well,
Because here you've got a party. I mean, you've got grandfather is a party too, and
the statute is specific in that it says any party or interested party. Interested party is specifically defined within the code as including grandparents.
okay, so he's
So
the
that's-
interest party. But I'm just asking. I think you've been putting the emphasis on the any that talks about any order. which was also the emphasis, I think, in NAC. But it strikes me that there's another any running around in that statute that could have bite, because your client is an interested party.
Right. Client is, well, obviously, father, mother,
And the only kind of
Relative.
appeal that interested party is going to have from a termination is if it's denied, right?
correct.
At least here.
Or the state. The state is
The
a
state,
party
obviously.
that obviously
But this is a
interested.
private action, as you
Correct.
previously pointed out. It just strikes me that that's kind of meaningless. It's an illusory right to appeal if that any party or interested party doesn't get to do anything
Correct.
if the termination proceeding comes out against them.
That's correct, Your Honor, and that's why we're here today, is because it is grandfather's position that he hasn't gotten to be heard on the merits of his termination motion, and that as an interested party, it is in not only
you
best
got
interest
to
of
be
the
heard in
child.
the district court. I think that's a kind of a weak sister in your lineup of arguments, because you got to be heard in the district court. Appeals are not a matter. There's no constitutional right to take an appeal in this situation or others necessarily.
Correct. It's a
It's all
statutory.
statutory. Yeah.
Yeah.
Okay.
Yeah, and we can see that we don't have the right to just walk into an appeal court and say we don't like how the court ruled. We understand that it has to come under the statute, and that's what we're arguing here today, is that this statute is not ambiguous. And in fact, if you look at the Court of Appeals,
I don't understand that last argument, counsel.
sure.
Why wouldn't the statute just say an appeal may be taken by any disposition, period? Why do they have to put in termination of parental rights
Well,
if you say that's covered by a disposition?
I think, I'm sorry, go.
No.
Okay. I think that if you look at the statute itself, it anticipates interlocutory appeals within the sync process. And this court discussed that in the NAC decision, that part of the issue, part of this goal of moving these sync cases through quickly and finding permanency for the child is making sure that if along the way the district court enters an order that is an abuse of discretion or that is contrary to the evidence, that there are quick and timely appeals available. And it illuminates that timely appeal is available off of an order of temporary custody, off of an order of adjudication, off of a disposition. All of those are not technically final rulings. And the reason why we take these rulings up in the midst of a sync action is because if the sync case has suddenly taken the wrong course because of district court abuse, then the appellate courts have the ability to come in and review it at that time. And so this idea that, we have to have a final disposition, there has to be a final finding that this kid is assigned to this person, that is not necessarily what the statute anticipates.
I'm still unclear. I understood your answer to a question by my colleague earlier was a decision that parental rights would not be terminated, such as we have here, could fit under the heading of a disposition. Is that right?
It could, Your Honor. But it is our position that it fits under termination of parental rights.
And would a termination of parental rights also therefore fit under the heading of a disposition?
Correct.
So my point is, why have that specific point in there if it's already covered by the general term disposition?
And that I can't answer, Judge, because that's the legislature's crafting of this statute. I think the legislature crafted the statute in anticipation of appeals throughout the sync process to make sure that on each step of the sync process we are doing it right.
Could they not have accomplished that by simply saying any adjudication
They could have.
or disposition?
And then you'd have, conceivably you'd have orders from the denial of the recusal of Judge Rumsey. Then you'd have an interlocutory appeal at that point because that would be any disposition
Or visitation rights.
or visitation rights or,
But here, really, we don't have a change of disposition. Your client, the grandfather, had custody and then became a permanent custodian. Arguably, the permanent custodian ruling was a disposition, stabilizing the custody, but the denial of termination didn't change the child's disposition.
it didn't change where he went to bed at night. You're right, Judge.
So really, we don't, even if we buy into the notion that a denial can be a disposition, in this case, it really wasn't, was it?
Well, I don't know that I would agree with that, Judge. I think that denial opens up the possibility, and the judge says that straight up in his ruling. He says, well, just so you know, this is going to cut both ways. Dad can come back in and ask for visitation. Grandfather, you can keep motioning for termination of rights. So we're not ending anything when we deny parental right, or deny parental
We're leaving possibilities open, but we're not changing disposition of where that child is going to live and who the caretaker is going to be.
In this case, you're
Right.
correct, Judge.
That's what I'm
Yeah.
talking about. This
Correct,
case.
correct.
Okay.
All right, I'm out of time.
Any further questions? Thank you, counsel.
May it please the court. Good morning. My name is Graham Brazil, and I'm here on behalf of the natural father in this case, the cross appellee. In this case, this court should not allow the grandfather to simply read something into a statute that's not there. Since the jurisdictional issue is kind of the precursor to any of this other analysis, I'd like to start there. And first, I think we need to look at what the clear language of the statute says. Clear language of the statute. An appeal may be taken by any party or interested party from any order of, list of orders, termination of parental rights.
So
Justice
does
Biden.
any order of modify each of those 5 things?
It does, but in this case, I think the word any, I look up in Merriam-Webster's, any is defined as one or indiscriminately of one whatever kind. So any of the list of those 5 orders could be appealed. It doesn't necessarily mean any type of order related to any one of those 5 orders.
Why would they have to say any order of termination of parental rights? Because you're taking the position a termination of parental rights is a standalone thing. It's just termination. And you can't, any other orders in that proceeding are not appealable. Isn't that what your position is?
Yes, Your Honor.
And so
They're
why,
not-
well, if the any order of modifies that, then that kind of cuts against your argument, doesn't it?
I don't think it does. I think that any modifies the list. You can appeal any one of those 5 orders. I think the Court of Appeals opinion has language that would suggest any type of order under each of those 5 orders, where the Court of Appeals on page 20 of its
So
opinion...
you're deleting any of the following orders.
No, Your Honor.
Because
You
any
can,
order of, I don't understand why that language means any of the following orders, is how you're reading it.
I'm reading it to say, yes, so when the statute says any order of temporary custody, adjudication, disposition, I'm suggesting that their use of any of just says you can appeal from this list of 5. I think we're talking a different story when, as the Court of Appeals suggests, if there was any relevant order of temporary custody, adjudication, disposition, etc. That changes the game. That word relevant order isn't in there. It's just not there. There's a list of 5 things that you can do, and that's it.
And it also doesn't say the order.
It does not say the order.
The order, and NAC, we basically said there is an order of adjudication, an order of disposition, and it's sequential adjudication, and so in that, if that were the case, you would expect it to say the order. Wouldn't
That's
you?
correct. But in this case, Your Honor, I think you're hitting on something that's interesting, and I want to talk about how grandfather in this case has not brought before you any reason why appellate review of this issue is uniquely important. In the court's ruling in the district court, Judge Brooks
Well,
indicates
we're,
you can...
we're not talking policy now. We're talking about plain language, and you started out by saying this is just read the statute and you win, and that's I want to pursue that. I want to get nailed down
Sure.
why you think that we can read those words and say father wins.
So I'll break down 2 any's. I think Justice Beyer raised the issue of that first any, right? Any party, the way this statute is constructed is we have 5 separate types of hearings. Those are various amounts of issues that are at play there. It's conceivable that an interested party could appeal an order of disposition, whereas a state would be interested in appealing a different order, right? There are different players in this game, and we've involved them in one statute. I think that explains the first any. is, right, we could have an interested party appeal a disposition, but they're
But-
not necessarily
But
going to
under
be.
your reading of the statute, the one that's at issue today, not talking about, that's most at issue today, not talking about the disposition provision, but of the termination provision. Under
Right.
your reading of the statute, if there's been a denial of termination, the party that was advocating for termination, whether it's a state or private party like here, is just, that's it. They don't get an appeal.
Correct.
There
They
is
don't
no
get an appeal.
appellate right for them.
Yeah.
Okay.
In no circumstances is there a denial of a termination under our
We
interpretation.
shouldn't read that they get one out of the any that precedes party or interested party.
No, Your Honor.
Okay.
Are there any other questions about plain language? I do want to turn to the policy considerations. And in this case, I think the policy weighs very heavily towards reading the statute in such a way that says you don't get an appeal from termination. As I alluded to earlier, the appellant grandfather in this case makes no argument as to why we need to have appellate relief in this case. She answers this somewhat in her supplemental brief and says that not allowing an appeal and having a subsequent termination motion is inappropriate. That's the word she uses. That's the only argument that's there, is that it would be inappropriate to do so. The two reasons I can parse out that she says it's inappropriate are, one, because there's more litigation. Well, we're here. There's more litigation in the appellate process. The question is, do we have that litigation in the district court with a court that hears evidence, sees witnesses, knows what's going on in the case, or do we have it on appellate review? I think it would be more beneficial to all parties to have that subsequent review of this be done via another termination motion that's filed by the parties in a court that can hear evidence.
Didn't we talk about in NAC that the majority talked about the problem was serial litigation, impacts stability for the child, and you're saying that there's not a problem here because grandfather can file subsequent motions to terminate, and so we can keep litigating in the district court. How does that achieve the stability that NAC said was paramount?
Right. I think that's important to consider, is this question of how long is this litigation going to go on. But I think if you accept the other side's interpretation of this statute, that you can appeal the denial of a termination, then we're looking at, you can appeal the denial of a temporary custody, you can appeal the denial of an adjudication, you can appeal any sort of dispositional order that you want to, you can appeal a finding that you're an unfit parent. That seems to explode this issue of litigation much more than a simple reading of the statute that says, look, you get these 5 things on appellate review and that's it. You don't get anything else. It's just a question of where that litigation is going to occur. And as I referenced earlier, I think it's actually more beneficial for the grandfather in this position to have his motion heard with a court that hears evidence and doesn't have to fight this abuse of discretion standard on appeal. If he really wants to seek termination of rights, then it's more beneficial for him to file again in district court. But he didn't do that here. He chose to take this on appeal and had his appeal denied.
As he gets more evidence of the appropriateness of termination.
Yes. And, Your Honor, I'm glad you pointed that out. There is a prior AS case that was discussed in 1988, I believe, by the Court of Appeals that addressed this issue of termination, subsequent motions, and res judicata. In that case, they said that you are more than welcome to file subsequent motions. There does need to be some sort of an additional intervening circumstance, some sort of more facts, some sort of something extra that happens. But they do say that it could be nothing more than a parent refusing to change their course of conduct. If we refile, we wait 5 or 6 months, biological father still hasn't done anything, it seems like the case for termination is much stronger for grandfather on the case of you've not adjusted your circumstances. There's no reason here why appellate review is necessary. And even if for some reason this court believes that, yes, we should have appellate review in this case, we should say that termination is appropriate, that's a question for the legislature. They can clear up this ambiguity. They can say you get any order regarding, adopt the Court of Appeals language. There's plenty of remedies and ways to rework this statute for the legislature. And yet after NAC, after AS, there's no action by the legislature. They've left it the way that it is.
Counsel, what if the judge in a case was denying the termination of parental rights and everybody in the courtroom agreed the judge was just not looking at the evidence? The judge was clearly disregarding the applicable law. it's your position that the losing party there, their remedy is with the legislature to get the statute changed?
I think there are other actions that that party could take as well. I think a 6260 motion, I think you could look at filing other motions to seek a new judge, seek a subsequent review on a different motion. It's not like you can't appeal, it's ball game for you. You have the option to look at other remedies. This is a civil proceeding. It's governed by the Code of Civil Procedure, and we have tools there available to litigants who think that they did achieve a result that's not in light of the evidence that is outside of an appeal. I don't think an appeal is necessary to get relief for somebody who gets a ruling that they don't like in district court, especially in this context. I do want to explore a little bit this tension between the TDW and the AS decision. In TDW, we have the Court of Appeals saying, yes, we can review this termination on appeal. First, there is some tension between these two decisions because there's a discussion of this issue of finality. I don't think we even need to bother with the question of finality. That's something that appears in the Code of Civil Procedure in the statute there regarding appeals, a final decision. Here, we have a very specific statute in the Sync Code that talks about appeals, so we don't even need to engage in finality. We've got a specific statute. We can look there. We don't have to look to the Code of Civil Procedure. In TDW, it was a twofold order. Not only did the court deny the termination, but they also ordered the immediate preparation of a reintegration plan. I think that is the key factual distinction. In AS, there is an appeal of only the termination motion. In TDW, you have kind of a dual appeal. You have an appeal of a termination, and you have an appeal of what's an order more like a dispositional order. In NAC, this court described that disposition, and this isn't the precise definition, but you say that we are weighing whether or not the parent should have custody, and we should evaluate whether or not reintegration is possible. It seems very clear that in TDW, we had that order when we had a reintegration plan with the parents ordered. That's the key distinction there is, yes, you can appeal TDW as a dispositional order. No, you cannot appeal AS as an order of just termination on its own. I also want to address here, it was one of the issues that were raised, whether or not this could be characterized as a dispositional order. Chief Justice, I think you're correct that if that's true and we could just characterize anything as a dispositional order, then the statute wouldn't read the way that it does. Each of these hearings are terms of art. They have very specific meanings, very specific ways that they are conducted, and very specific findings that are made by the district court. I don't think we can just lump it and say, well, because a termination sort of affects permanency of the child and it sort of addresses where the child's going to live, I don't think it's right then to say it's appealable as a dispositional order. I think that blurs pretty clearly defined lines and the terms of art that have come to evolve out of the Revised Code of the Care of Children.
How would you then define disposition?
I think this court's characterization is appropriate. A dispositional hearing is we're evaluating whether or not a parent should have custody, and if not, whether or not reintegration is possible. So there we're not looking necessarily at the legal relationship between parent and child. We're kind of charting a course for the rest of the case. All right, what are we going to do here? Are we pursuing reintegration with this parent? Is that something that's viable, or are we looking at adoption or some other form of permanency?
So if an order includes if the order denying termination of parental rights includes a reintegration type of order, you get to appeal that, but if it doesn't, you don't?
So I don't know necessarily that I agree with the reasoning of TDW that then you get both bites at the apple.
You said that's what distinguishes it, and it seems to me that then leads to
Correct.
An appeal of the termination.
I think it gets you an appeal of the dispositional portion. I don't know that it necessarily
it's
gets you
somehow, and you just get to appeal the dispositional part, but not the termination. I don't know how.
I think that's a reasonable approach. Then you can say, all right, we're going to appeal whether or not reintegration is a good idea with this parent, but we're not necessarily going to appeal the question of whether or not the legal relationship exists between parent and child. They're two separate inquiries.
I understand they're two separate, but does one lead to the other in the scenario where there is a reintegration plan attached?
I guess we follow if you could appeal the disposition, can you necessarily appeal the termination as well?
Right. I mean, if they're together. I mean, if they're part of one disposition.
I think the interpretation where you could appeal the dispositional order and then file a subsequent motion for termination in the district court is equally viable. I don't think appellate review of one necessitates appellate review of the other.
Am I understanding that your argument to be that there is a disposition or dispositional order, that after you have a adjudication, you have an order saying this is the course that we have set for this case?
I think there's an
So
art.
how does it, if that's your argument?
No, Your Honor. I think that
Okay.
there could be multiple dispositional orders throughout a case.
Okay.
For example, we are well past 60 days beyond adjudication in
Right.
TDW, but that was a dispositional order.
And the course of the case often changes, which is why you have permanency planning hearings
Certainly.
periodically mandated, because reintegration can disintegrate.
Absolutely, absolutely. I think that's 100% correct. I see that I'm almost out of time. Are there any further questions from the court?
I see none. Do you need any time to wrap up? Do you believe you've made your points?
Thank you, Your Honor. I'm just fine.
All right, thank you, counsel.
Thank you.
You reserve 5 minutes for rebuttal.
Thank you.
Counsel, let me ask you, I'm kind of struggling around with the
Sure.
file when I get on the computer in the file. Notice of appeal in this case was filed in December of 2015, is that right?
Yes, Judge.
What's been happening in the district court case with this child since then?
Well, actually, Your Honor, we, our grandfather is permanent custodian. He makes all custody decisions, and at this time, continues to deny visitation to biological father for all of the reasons in the record. When father feels it is in his best interest or chooses to, he files a motion requesting visitation, or there is some sort of court proceeding. Typically what happens in these court proceedings is the parties come to court, father explains his position that he believes he should have rights to his son. The court hears the evidence, asks if there's any real change of circumstances. There isn't. And the father's request for visitation is denied. The most recent one of those hearings was in November of 2017. Typically, it's in the record in this case. The father left the courtroom when he was determined unfit. He typically leaves the courtroom when he's denied visitation. It's not a good situation. The goal of the grandparents at this time is to just protect the child from his biological father, who they deem to be not only unfit, but a danger and a difficult influence. So,
Why doesn't it make more sense to get this case, this appeal out of the way and make another run at terminating
well,
with the
because
district
Your
court?
Honor,
You can't do that until this case is out of the way.
I
So
agree.
You're spending 2.5 years so far.
Right. There's a lot of reasons unrelated to either grandparents or biological father as to why this appeal has taken so long, and a lot of it has to do with prior attorneys of record and things that had happened in this case that got mucked up in the system. Unfortunately,
That happens a lot, doesn't it?
I believe it does, Your Honor. So we have a situation where grandfather spent 2 years litigating this case while it was fresh, while dad had visitation rights, while a reintegration plan was being tried and failing. During that time frame, is there not the best record and the best time to make a decision of termination at that moment? When we've had 6 days of trial, we've had literally a litany of witnesses, from educators to social workers to ACASA, who have all recommended termination. And Justice Ness, your point of what do we do when we have a district court who makes a ruling contrary to every witness at trial? That's this case, Judge. Every single professional who testified said, father is unfit, termination of rights needs to happen. The CSO in this case created a report with 17 enumerated reasons why father's rights should be terminated. Despite the evidence in front of him, Judge Brooks said, I find it in his best interest not to terminate.
Is the district court's determination that it was not in the best interest of TS a legal conclusion or a factual determination?
I believe it's a factual determination,
And
but
so you have to hang your hat on convincing us that the evidence was insufficient without our weighing that evidence or assessing credibility.
Exactly, Judge. And so what I have
And
to
do we
do is.
decide that? If we agree with you that the Court of Appeals was wrong in denying jurisdiction, our typical scenario is when it's a process ruling that we overrule, we send it back to
Send it
them
back.
for the merits. Do you have an argument for us, because it's an expedited case that's already taken way too long, why we should, if we decide to overrule the jurisdictional, why we should go ahead and keep it on the merits?
Yes, Your Honor, and that is preserved in both our petition for review and our supplemental brief, that we believe the evidence in this case was overwhelming enough and one-sided enough that not only should you decide the jurisdictional issue in favor of the grandfather, but you should also enter an order terminating father's rights, or at least asking the Court of Appeals to address that issue on the record before it. Very briefly, I think it's important, we've talked a lot about statutory interpretation, plain language. If we look at page 20 of the Court of Appeals decision, the Court of Appeals quotes the statute in question and says, plain language, plain language, plain language. Then look what the Court of Appeals does in the first paragraph on page 20. They add a bunch of stuff to the statutory language. So they're not applying the plain language. They add parentheses, numbers, additional words. They paraphrase, characterize. I think that shows right here that the plain language of this statute is not followed if we deny an interested party the right to appeal what is a very important issue, which is how we protect these kids who are children in need of care. Any other questions?
Does that conclude your presentation?
It does, Justice.
I see no more questions. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time.